Hi, GC News. Meba ubibia kwaba hadi latest hot ekwa era mede bramo. Anunti se unya subscribe to channel dia bomodi ase obe subscribe. Rawe se obe click the subscribe button no. Na wabele notification no. We had sa video fufuru bia be upload no. When the first person was ebeka sa video. Afi we are na like video no. Give us a thumbs up. Na fi share ma wo fufuro so da wenye bi hwe na wo hu ensemo a ekoso ewo gara memwa atentemara yembura ye ensemo abeto yepono so inti yes report ya babetu dwa mu iti sansemu.
In Ghana, our Supreme Court has a jurisdiction even to entertain appeal from the National House of Chief. Our Supreme Court has a review jurisdiction. Our Supreme Court has a jurisdiction that allows it to make a determination as to whether a document or information has national security implication. My brother here has been litigating that matter with the then National Security Minister, Dapaah. So, aside its original jurisdiction in Article 2, it has many other jurisdictions. And the position is that this actually compounds the work of the judges. Incidentally, you notice that Supreme Court judges that we have now, it is either 62, 63, 64, 67, and others. Imagine the workload. And so the idea is to bring this 7 to augment relative to the workload. I mean, it's legitimate. I will not begrudge my senior here if he expresses a certain view. I mean, that's what makes our democracy what it is. What I found extremely worrying, and I'll say this. Yes. Currently, we have 48 justices of the Court of Appeal. 48. Please check the number. 48 justices of the Court of Appeal. Only 4 were appointed by President Mahamadu. 44 appointed by Akufo Addo in 8 years. 44 justices of the Court of Appeal in 8 years.
And then we have the records of that. We'll put it on the screen as you
perfect.
Yes.
As we speak, from 2017 to now, Akufo Addo had appointed in excess of 15 Supreme Court judges, some now on retirement. My Lord Ashikote, my Lord Nene Amegache,
I think it's like, you say 18, 19.
Yes, in 8 years. He's done in excess of 15 Supreme Court judges. All of them.
But Kayesu is also on retirement.
Yes, now. So that's in excess of 15 in 8 years. Now, if you look at the High Court, it's over 113. 113. Over 100 High Court judges in 8 years. He's the president. He has the power to do. And that's what he has done. President Mahama is exercising the full benefit of his powers as president on the basis of need assessment. And so where there's a need, he will fill in the gap. What I just want to say on this matter of appointment is that over the week, the minority had a press conference addressed by the Honorable Afenyo Markin. And he made the point that the reason why President Mahama has nominated these 7 Supreme Court judges, if approved by the Parliament, is that he wants a 3rd term.
Very ridiculous.
My learned senior Afenyo Markin, what is happening? Senior?
Disinformation is deliberate.
I mean, deliberate. Deliberate. Is it misinformation or disinformation?
Disinformation.
Disinformation. Okay. Look, why would a member of Parliament deliberately court public disaffection for a president who is sometimes called his friend, right? on the basis of deliberate, I call it misinformation. Because one, President Mahama has already publicly said that he has a farm in Savannah region that he can't wait to go on retirement and go to his farm. President Mahama had made it clear that uniquely God has been so merciful to him. Look, in fact, today in Ghana, in the next 100 years, only 25 people can become president. That is even if they are doing 4 years, 4 years, 4 years. Out of 32 million. God has been so kind to him to even think of tinkering with the Constitution. In any case, assuming, even for the sake of argument, that there is even an attempt to amend the Constitution for a third term, assuming without admitting, what has the Supreme Court judges got to do with the amendment of the Constitution? Because that provision is very, very entrenched. The one that puts term limits is entrenched.
So there has to be a memorandum.
Referendum. Afenyo Markin knows this. He knows that even the threshold to amend that provision would require some MPP members must vote. Because that is a very strong threshold. He knows that the Supreme Court has no say. So if you recall, the initial argument was that this removal of Chief Justice process is because President Mahama wants to extend his tenure. What has the Chief Justice or Supreme Court judges got to do with attempt to amend the Constitution as it were to lift the term limit? So this deliberate, mischievous attempt by Afenyo Markin to court public disaffection for the person of the president, I have always said, as an appointee of the president, I pledge that I prefer to go down for the president to go up. And the reason is simple. Ultimately, responsibility lies with him. President Mahama has demonstrated greater fidelity to the laws of this country. He has shown that he will not do the impossible by attempting an amendment of the Constitution.
Yeah, that one.
Never. And his patient doesn't even allow him. Do you know that he had intervened in other African countries where presidents have attempted to change the,
that place he scores greater than his predecessor.
Yes. Look, even Akufo Addo didn't amend the Constitution for a third term when you are talking about President Mahama. Let's be serious.
You see, so we're doing all these things. When I say we, that's the people actually at the bottom of this. Okay, for selfish ends, you say, yes, people will twist what the Constitution says. People would, and that's the nature of law, all right? That is so flexible, okay? It accommodates. The meanings expand. So people with various interests can hide behind the law. That's it. So it's about clarity of thought, the way the law is expressed. So if it's not expressed in such a manner as to give only one clear meaning, then there's room for people to come in with their political ends, right? So you see, in all of this, for me, what I see, so from when earlier on I'd made that point, and it's a point we've been making months before, and even if we go back, we see that for years, other commentators have been raising this. We will have to amend the Constitution in that regard. That one is no-brainer. It's clear. So we are talking about Article 144, right? Yes, that's where you have the president acting in consultation with the Council of State, all right? And with the approval of Parliament, the Chief Justice, right? Then you come to the other Superior Court justices, etc. We have said it, thankfully, it's something we've been saying for some time now before this matter came. So nobody can say that, we are also on one side or the other. Because the thing is it's unwieldy. It's unwieldy. If you talk about separation of powers, then you can have the head of the executive, right, play a crucial role in the removal of the head of a coordinate branch. That's the judiciary. That it means that we almost have no separation of powers. So you remember when Chief Justice Torkonoo wrote the letter to Akufo Addo last year, and then we had to debate it. That's a list of 5. Yes, I kept using this phrase that in Ghana our constitution is modeled in such a manner that you buy one, then you get one free. Buy one, get one free. Yeah, you buy the executive, so you are president, then you get the judiciary for free. Yeah, that's it, for free, through appointments and also through financial inducements. So it's only buy. You buy one, get one free. So it's good that we started making this noise, and I mean, this case has brought the arguments back, and so I'm sure Professor Kwesi Prempeh is following. Yes, and I'm sure even he would at this debate himself, he had shown through his various submissions and etc. that it's not a system that he likes. No, nobody likes such a system, because to build a stronger society. Yes, we've made some progress, but naturally, this constitution, Tróuble doesn't like hearing that. But it's generally accepted that it was written to appease Rawlings, okay? But Tróuble will tell you that no. But of course, we are Ghanaians. Others can also read and make their own judgment, right? So now that Rawlings is been off the scene for some time, we need to rework it and give stronger independence, because look, the politicians are not angels, and none of us sitting here too is an angel. So we need to write the constitution and in a manner to reflect that we are human beings, not angels. This constitution is written as if human beings, where our presidents, our politicians will be angels. So in other words, that's why we've been talking about the philosopher king. This is a philosopher king kind of a constitution. Yes, but we are not philosopher kings. We are not. Lots of us fall short in various areas of our lives.
So why is the GBA's position a departure from what the law is?
Yeah, so this
on the
GBA
revocation of the suspension.
You see, the GBA thing, I like the interpretation Lawyer Mam is put on the GBA thing. So perhaps they shouldn't have called it a resolution. You see, what the GBA has said, look, to be very frank, speaking openly, and because this is a matter we had been raising here before Chief Justice Torkonoo's matter came, you can see that I have a soft spot for it, that we should tighten the constitution. A soft spot for it. But the GBA went too far by calling it a resolution. You see, so you see what Lawyer Mam is saying, that it's an appeal. They shouldn't have called it a resolution. The moment you call it a resolution, at this time that we are saddled with a hard case, then people will read politics. Especially, it doesn't help if Wagati, you see pictures of her with her husband on a campaign platform. If Wagati in MPP colors, you see, if Wagati, so that's wife of Joe Gatti. Joe Gatti was what? Former Minister for Railway, former Attorney General, former board chairman of GP,
presidential,
etc. You see, yes, and to be honest, look, I don't hide it. I supported Efuagati to be president. I supported her. You know why? You know, I always like balance. By the time does this, listen, I knew NDC was going to win, even if by 100,000. It was clear that with the misgovernance and everything, NDC was going to win. So I wanted opposition. So I said no. Efua comes from MPP, so I wanted, but I didn't know she would descend this no. So if I got it, this one there, no. That's not how. That's
are you by this withdrawing your vote?
I'm not withdrawing. So you know that I still support it. We need, you see, like Lawyer Mam said, you should have made it an appeal. I have a soft spot for what you're saying, that we should tighten the rules. We have been saying it here before this matter came. But to call this a resolution, no, it was too much. 47 people. Even look at the way people, lawyers are raising arguments about the timing of the conference. People didn't get enough notice, etc. So that one, this is. I call it Dinah Asunaba resolution. I know. That's it's interesting, you know, politics. So if we are this one, let's have another meeting. We'll cancel it and call it. If you call it an appeal, I'll be first to sign. If you call this an appeal, I'll be first to sign, because every Saturday I come here, this is a matter we have been raising. That no, let's strengthen the constitution. The president shouldn't have a rule. Chief Justice Torkonoo also said it in 2023 at a vetting. The president should not have a role in this. It's something we've been saying all along. But don't call this a resolution. You won't get my support for it. You You get. I mean, so now you see how they've embarrassed if we are getting in her MPP colors on the campaign platform.
No, but you compare her first statement, her initial statement, and this one. The initial one was basically telling all stakeholders, hold on to the process integrity. And for me, in fact, I felt it was so measured, fair comment, fair to all sides. Have you heard President Mahama, from the time the notice of suspension came, or from the time he received, say the Chief Justice is guilty?
No.
Never.
No, it wasn't.
It is for good reason. Allow the process. Trust the process.
Yes.
That is what you do in a democracy. Yes. Have you heard President Mahama on platform attacking CJ before or prior to? No.
No. No.
In fact, in the case of CJ Torkonoo, for the record, her approval in Parliament was bipartisan. Was bipartisan. Both NDC, MPP, MPs, even in the hang Parliament, unanimously supported her approval to become the Chief Justice. Okay. It was a greater confidence in her. President Mahama, as we say, anticipated that the things in the petition will happen. Is it by way of clairvoyance?
You make
okay.
Point.
Yeah. So moving on. So let's just see, how we move forward as a society. Because listen, no matter where it is, bottom line is the interest of Ghana. That is what we all must look at. The interest of Ghana. You cannot use the GBA. Look, I have my phone full of messages from lawyers and lay people. Very, very disappointed in the GBA. So look, if we are getting this one, you even must be the one to even ask for the next extraordinary meeting. Yes, she should lead it, because now you've been embarrassed too much. We can't take this from you. So she should lead it so that we'll reconvene. Then we will cancel this resolution. We will cancel it, because you can't put the bar into such a, what do you call it, disrepute. Look, my phone is full of messages from lawyers. People are very upset. People are very, very, very upset. Maybe you should interview Efua that, look, why did she drag us into this kind of thing? I mean, yes, we want some opposition. We don't want a GBA president who is not to be aligned or secretly aligned to the NDC. That's why I supported you, but not this type. This brazen kind of partisan, like it looks more like MPP agenda. No, it doesn't look good. It doesn't look good on the bar. I think we have to reverse it, like the way Oliver said it. And I think it will restore credibility to Efua Gatti herself if she leads the process. Yes, you send a resolution at the request so that people would request, and then it will be saying that you listen to the bar, and you heard that, well, where the bar went to the purported resolution, it's damaged us. So you also lead the rehabilitation so that we go back and then undo this, because otherwise, I mean, it will go down in history that you came and all you sought to do was just a partisan agenda for the NPP. Yes, because that's what it looks like. It doesn't. I mean, come on. It doesn't look good, because if you see Efua Gatti in MPP dress all over with her husband, it looks very bad. It looks very, 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 very bad. Very bad. Let's do something to restore confidence in the bar association, because now you've given opportunity for lay people to take pot shots at us. Pot shots. Everybody say everything. The bar is disappointing. The bar is hypocritical. The bar is MPP. All that. No. Let's do something about it.
So, and let me, so that I'll just run up. And there's another aspect of the demand of the GBA that we'll get into. So to the extent that the suspension could be described as merely administrative, and the president doing so not alone, but in consultation with or acting upon the advice of the Council of State, it's essentially perfunctory.
Absolutely.
So why should a perfunctory administrative function be administered by a legislation?
I think that His Lordship Justice Dateba envisioned a situation we have today. So if you look at Branford France, and just for the record, you know the lawyer who argued Branford France? It was my company law lecturer there.
Your senior was him.
No,
he came by
So that time, the EC had decided to create the 45 new constituencies in 2012. Then Ransford France, led by his lawyer, the Honorable Joe Gatti, my company law lecturer then, approached the court and said the same Article 296C should invalidate the process because per Article 47, the Electoral Commission had not come out with CI to guide the May appearing in 47 on the creation of new constituencies. And then His Lordship Justice Gertrude also, even for the sake of argument, assuming there is even a non-compliant, it does not invalidate the decision taken. It's clear in the decision. Then he now proceeded to now draw the categories and say that, but if you're a quasi-judicial body, at least let people, so the Judicial Committee, for instance, of the National House of Chiefs, you should have some CI, at least, so that persons appearing should, for instance, have an idea. If there's a petition against me, what's the timeline to respond? Like CI 47. So people can prepare. And these things ensure procedural fairness. Right. This thing ensures a certain level of candor. However, if the decision is not adjudicatory, then the requirement of 296 does not even come in. More importantly, Alfred, is the question that, and in this specific case, where the prima facie determination is not adjudicatory, and in this, you know, like the particular case of the CJ, with the opportunity to appear before the committee, should go with her lawyers, should call witnesses, the petitioners have the opportunity to call witnesses, their testimonies will be cross-examined. At the end, inferences will be drawn from the evidence. That's adjudicatory. So there's so much clarity.
I'll disagree a bit.
What?
You see, when you look at it, if we are talking proper, if we are talking pure law, as I said, not in it. When you take a decision that affects somebody's rights, okay, a decision, anything you're going to take that affects somebody, it's judicial or quasi-judicial. There can be no argument about it. So if the person is CJ, and you are suspending the person, there is some quasi-judicial...
Hold on. It runs for France. No, I beg you.
France.
No, hold on, I'm coming.
Proper,
no, so I am coming. But you see, His Lordship Databa, when he said reference to quasi-judicial, he proceeded that by quasi-judicial, I mean adjudication.
Yes, so the suspension is an adjudication. I'm telling you.
Which one?
You look at the papers and come to it. No,
the suspension is
an adjudication. On the
what point does the adjudication start?
You see, a prima facie. No, hold on. A prima facie can be determined. But you decide not to suspend.
Yes.
In the case
wait. The word is determined. You see, let's not mix them.
How?
The word determined. No, it's
we take decisions every day.
One of the things I'm worried about, or thinking about, is what would regulations look like, and how would they apply in this particular context? And that's Professor Kwesi's points on this thing. What would the nature of it be, the decision whether or not to suspend the CJ?
Oh, certainly you can do something about it. So let's come this way. Number one, I want us to go first principle. The question is that in law, do we agree that if you take a decision that affects somebody's right, it's either judicial or quasi-judicial?
No, but hold on.
My question is, what would regulations and adjudications within this context mean? How would they look like? The regulation ought to be reasonable, fair, and candid.
Absolutely.
Perfect.
Okay.
So you make
those standards already exist.
No, that is why
the word is
at 23,
candid.
yes.
Listen,
And I'm saying that
you have to break it down. No, listen.
No, but the decision has to suspend.
Senior Martin.
I don't know how.
Let's not mix them. A quick rebuttal. Senior, if you look at Awuni NYA, yes. The contention was Article 23. In the sense that Article 23 imposes And he carefully used the word administrative bodies.
Yes.
And now introduces the concept of fairness.
Yes.
And so if you look at Sofa Akufo's reasoning in Awuni and Wayek, he says when we say administrative bodies should be fair, it requires, for instance, where there is a duty to hear the person, you hear the person. You get it? So that at least there is an input before the decision is taken. That in and of itself does not make me.
That's what I want to understand. Whether on the decision to suspend, we then have a hearing of the Chief Justice. So we have to hear her first.
How?
There's a way
How?
If you want to do it.
Because I don't see that practice.
Legally untenable.
You hear the response. The response is a hearing. You
No, but that's for the prima facie.
Yes. So you looked at it.
Yeah, it's
But the suspension is divorce.
But let's talk about something else. I think that the problem of
Let's not shout. Let's slow down. Let's talk one at a time. I'm telling you that what the Chief Justice gave to President Mahama is a response. So he, by reading through, it's a form of a hearing. We have affidavit hearing. We hear on the affidavit. So he's taking a decision based on what he's read. If you want to tweak to make sure that the exercise of the discretion is this is regular, we can do it. I'm telling you.
I don't know any comparative constitutional example. No, the reason why I'm saying this is that, listen, on the Constitutional Review Commission, I was in charge of the judiciary brief. On this very question, I don't have any example that says that beyond the requirement of hearing, how do you do it?
So it can be done.
So there's no example anywhere.
No example anywhere. So can't we do it? Can't we do it ourselves?
I'm asking that practically. So practically how? You can say that, okay, before you make a suspension decision, hear the Chief Justice again. To what point, whether or not I should be suspended? Okay, we've given you a hearing.
Now, so let me show you what it means is that
let's round up on this.
So just one sentence. So what it means is that when you get the response, what we're going to do is circumscribe the discretion. When you get the response, if it borders on this, yes, go ahead with a suspension. If it's that, no, we can do it.
No, but whatever the case may be, even in that instance, you cannot list everything that comes out of this.
Maybe I'll just I beg you. Let me just find out from my learned senior. Would you draw a distinction between a quasi-judicial function, quasi-judicial function, and a presidential duty?
Yes, they are different.
Perfect.
So
Article 146 hold on.
It's a quasi-judicial. Trust me.
Let's go.
That one, there's no way.
Who else can perform that function?
There's a reason why.
But it's quasi, so he's coming to perform a quasi-judicial function.
That's fine.
As for the process, that's the law. We can't do anything, but let's not make it look like.
That's why, to the extent that you, Oliver, you make the point, there's no reference to precedents. Martin Kweku says we can do something.
Because the law is clear that thing is quasi-judicial. Anybody who tells you that it's administrative is misleading.
Two positions that can never converge. So let's just hold on to that. It is what is existing now is what we are working with now. Okay, that settles the matter. A number of messages that have come through also bothering on some of the questions that have been asked already about this one from Kusib Boakye says the president in exercising discretion in Motie 3 didn't affect anyone's negatively. In this case, it's been affected.
If the Chief Justice complained, so, in direct response,
yes,
the Chief Justice, as we speak, has not said her rights have been affected. So where from this legal proposition?
Well, so
it's basic. Regent Baldwin, anything you do to affect anybody's right.
You are not get. But the president gave her the right to be heard.
No, it's a removal of
suspension. Hasn't been removed, Senior.
No, we have heard that international best practice recommend mandatory suspension.
Thank you very much.
So,
Professor Stephen Kweku Annan, good morning. It says suspension under Article 146 is not adjudicatory.
Absolutely.
It is a precautionary administrative measure.
No, it's not.
Much like the routine interdiction of public officers.
Absolutely.
Meant to preserve institutional integrity
and
pending
investigation. Let me finish reading the message, gentlemen.
Meant to preserve institutional integrity pending investigation it carries no finding of guilt and does not by itself trigger disqualification. Professor Kweku Asare, thank you very much for the message. This one here also from Lawyer Kakre, someone says, unfortunately, we tend to over-legalize public discussions, especially when meant for the, you says, the understanding of many. And that is one thing that I commend this platform for, that you break down the legal issues to the understanding of the ordinary man. This is coming from a lawyer, so you can understand. It says, in this country, a president without any prior notice fell down dead. The world didn't come to an end. Ghana did not collapse. What is special, it says, about a Chief Justice, that when she is particular and no more Chief Justice, this country would grind to a halt. It goes on and on. This one here says, good morning. May I suggest that the Chief Justice must be voted for by judges from High Court upwards. From among the Supreme Court justices, the President is voted for by the state, Speaker by parliamentarians. So why not the CJ? You say, and these are the kinds of conversations that the Constitutional Review Committee, as Professor Expóse is leading, would be entertaining going forward. Well, in that sense. But there was another demand by the Bar Association for the publication of the prima facie against the Chief Justice, consistent with the established precedent. Professor Expóse made that demand that it should be published after the fact. But this one, they say there's established precedent.
I disagree.
Do you agree or support this call by the Ghana Bar Association?
We should never publish.
No, let me find out for people and then to you.
Okay, so I support that we publish after the fact. Yeah, initially I wanted the primary facie now, but we've got the Ghana Bar Association that once bitten, twice shy. So let's wait and publish after. But as for publication after, it's not negotiable. Yeah. It must come out for us to read.
Yeah.
Charlotte says, it came out. Yeah, we got it.
That's the grounds. The grounds are different.
No, we got. Oh, the report came out.
Which report? The president never issued. Not even.
There's no public report.
There's no public record.
There's no public report.
So you support after the fact?
Yes, after the fact.
To be published?
Yes.
No, the danger for me, the danger is that if you have a situation where you publish, there are reputational issues. And so I believe that some of these things, there is a wisdom in why in the superior wisdom of the framers of the Constitution, they wanted in-camera proceedings. Because they anticipate a situation where a superior court judge or a constitutional independent body may come out with no findings, but the person's reputation will have been gone by then.
Yeah.
So I strongly believe that let's keep it that as things are now.
I struggle with that. Yes, I struggle with that. I mean, I think that one of the process why people have taken the view that the president is self-interested in the removal of Chief Justice is our tendency to want to obscure everything from the public. This idea, first of all, the Constitution says that the part that is supposed to be in camera is the trial itself.
Yes.
That view then has been extended to a point where we are saying that even if a petition has been brought, nobody should hear anything that the petition even exists. All the people will wake up to is that the Chief Justice has been removed. I don't think it strengthens public confidence in our institutions that the people's Chief Justice will only hear that the Chief Justice has been removed, or now that the Chief Justice has been suspended by the President, without even first knowing that the petition existed in the first place. So we have to be able to balance this. If our concern is that releasing it in the public can compromise the process, then after everything is done, we publish it. And the people are aware of the grounds for which the President, their Chief Justice or their Supreme Court judges were removed after. If there's no prima facie case found against the person, we publish it nonetheless. So that we see that the person was then put through a process and cleared.
Yes.
Now the President that they're talking about, they're only referring to the dismissal of Kweku Azare's petition, Professor Azare's petition by the by the former president that the reasons why he said there was no prima facie case was then released. In that case, you can even say it was after the process, because his decision that there was no prima facie case terminated the process. And so when he released that, then that's it. But it was never released in Charlotte Osei. There was no formal public record of not only the prima facie decision, but also the committee's work. Yes. None of those were made public.
In fact, it was their recommendations. So even to the president. And the president's statement removing Charlotte Osei, upon the recommendation of ABC, this decision has been taken. That is it.
Well, the third matter also directly linked to the justice system is the nomination of these 7 justices of the Court of Appeal by the president to be considered to the apex court. And we're talking about Justice Sir Dennis Dominic Ejay, currently a judge of the Court of Appeal, appointed in July 2010, also a judge of the African Court, having been elected to the court in July 2022 for a 6-year term. He's one of the 9 members of the advisory committee of the International Criminal Court, and his profile is quite rich and all. A good call, one you agree with, and how it also impacts on the justice delivery system, and especially the conversation about the number of justices at the Supreme Court and the upper limits that we are hitting now.
Okay, so Mr. Kansi, we rolled back maybe at least like 7 months ago, right? Or more, but at least not less than 7, because this is the 5th month we started. You know, when Chief Justice Torkonoo wrote to President Akufo Addo and the letter leaked, this debate, we had this debate. So everything I said at that time, I stand by that. So now let's recap. There won't be enough time to recap everything. I still don't have my time. So number 1, what happened at the time was that at that time, 2 justices were yet to retire, right? And President Akufo Addo wanted to fill in those vacancies, even when those people hadn't retired. And then the Justice Torkonoo letter came with 5 more. So I think, at that time, Professor Pong and then Justice Benasco had been nominated already, seeking to fill in Akayenzo and Mariama Owusu, who have not yet retired, right? Then Chief Justice Torkonoo brought her letter for additional 5, right? That was the context. Now, at that time, what we said was that, look, the convention, and as even recognized by the Supreme Court in the case of the GBA versus Attorney General, just briefly, that's the case in which, you even mentioned it earlier on, the case in which when President Mahama appointed Justice Puama and Apo, the GBA were not happy. They went to court that they expected that the press, not just expected, the law is that their reading of the Constitution, the president should have gone strictly by the order in which the judicial council had ranked the candidates, blah blah blah, right? So, but that's not the argument I'm talking about now. Right now, I'm talking about the fact that in that case, the Supreme Court recognized the convention. So my point is about the recognition of the convention, that you have 14 justices. Some say even including the Chief Justice. Others said no, the 14 you find in the GBA versus Attorney General case. The 14 refers to the rest of the justices. It doesn't include the Chief Justice, right? So whether you say 14 or 15, my point is that that convention will recognize it. When President Akufo was in office and then the number went beyond the 14, when we presented our report, the African Peer Review Mechanism, were chastised for it. It was a big matter. So there was a debate here in Ghana where Akufo was chastised that he had broken the convention, etc. Akufo leaves office, Atta Mills comes, then JM comes, and then there's a Supreme Court matter. The Supreme Court recognizes the convention. So based on it, the argument was that if you want to break the 14, or call it breaking the 15, let's have a conversation around it, a public one, and especially let lay people weigh in. Let them come and express their opinions. And I like to quote Samson Ladia did an interview with H. Kwesi Prempeh, the chairman of the Constitution Review Commission, where H. Kwesi Prempeh went into the writings of Adam Smith, the famous economist. He also had opinions on social justice and the justice delivery system, where he said that there can't be progress if, you know, the justice system doesn't promote commerce and manufacturing. Long story short, that statement has been interpreted to mean that those in manufacturing and commerce should also have an opinion on the justice delivery system. That's the argument. Those in manufacturing and commerce should also have an opinion. So meaning, let lay people also weigh in. If you are going to break a conversation, so I remember at the time, the statement I forcefully made at this same panel was that, or no, not the panel here, on this program, was that we couldn't leave the conversation to President Akufo Addo and Chief Justice Torkonoo alone. And then it happened that after saying so, so many people also joined in and said, yes, we can't leave it to those two people. And also President Mahamadu is on record to have also said, yes, when he comes, he will leave it to the people to decide. Leave it to the people to decide. You can let your producer pull it out.
Yeah, I think
President Mama said this matter of breaking the convention, he agrees that leave it to the people to decide. So this list of 7 is a surprise.
The decision of leaving it to the people is whether to reduce, maintain, or increase the numbers.
Yes.
I think that's the context in which it...
Exactly. Leave it to the people to decide. So if you also come and want to break the convention, then let the people weigh in. Remember, we all want an efficient justice system. So you see, the comparison, as I said, there's not enough time. We can't advance all the arguments. So for now, you know, we'll go to, so please, for those who say US, they have only 9 justices, etc. It doesn't apply because there in each state, they have a Supreme Court. So each of the states, 50 states, and then DC. Each state has a Supreme Court, right? So we can't compare to the Ghanaian situation. Bottom line is that we want an efficient Supreme Court, etc. We have cases that have been pending years. We are feeling it. But we've agreed that as a society to carry the people along, let's have a national debate. Then at the end of it, we break the 50. So
you're opposed to it because of the nomination because we haven't had a national conversation on the matter? Because this is a convention that's going to be broken?
Yes, so not the total nomination, but the nomination is going to 7. So if no, you know, since then, as I said, 2 justices have retired, and I'm aware some 2 are about to. So if for any one of them that's less than 6 months, or even 8 months, or even a year, I agree we can start the replacement process. So it's a number 7 that is causing the problem. Out of that list, you know, there are 3 that as a society we all agree generally they've been hard done by the previous administration. So number 1, the class prefect, or you call him the SRC president, that's Justice Gyamfi, right? He's a president of the Court of Appeal, ADG, right? Yes. To the president, far senior to some people who were appointed to the Supreme Court, right? Then Justice J, the scholar, everybody feels that it's because he's written extensively, and he's been on the Supreme Court since 2010. Yes, the Court of Appeal, he also qualified. Then Justice Sorebare, right? These 3, their matter has been well beaten in the public domain. So it looks like at least they are the constant 3. Then the rest, we can go into there. I know Justice Bright Mensah is also quite senior. But the rest of I'm hearing memories that the rest of the justices on the Court of Appeal are also not happy because they are raising issues of seniority. That there are far more seniors on the Court of Appeal than some of those people on this list. And that is an argument that was made when the other list came out. People who were senior to those on the other list raised issues. That's the time, that's the time we're saying that, but Dennis J has been there since 2010. Senor Gyamfi has been there since this. And now you see the chicken have come home to roost. Or if you like the other version, the roosters have come home to roost. So some senior justices on the Court of Appeal are also raising hell. That but a few months ago, you guys were here busy talking that Senor Gyamfi is senior. He's been sidelined, hard done by Dennis J. Sorry, Barry. Now, in this current list, there are junior people. So that's the thing. So let's go for the public debate, and then we'll reach a certain consensus, and then we move forward.
Well,
that's it. And let me quickly add. Just one second. You remember also a few months ago when I mentioned, Akufo Body, when Akufo Addo came and told Akufo Body to resign. I want to see Akufo Addo's face today. The man he orchestrated asked him to resign at all costs, and sending Godfrey Dami to Akufo Body all the time. Now he's CJ. He's CJ, acting CJ, you see it? You get power, you think the whole world belongs to you. Akufo Body should go. Akufo Body should go just because he voted against Akufo Addo in the election 2012 petition. Now he's acting CJ.
Well, why did you start? You see, and I'll come to you on this, because
you see,
reference is made to that 16-page letter that the now suspended CJ wrote, justifying the 5 that she proposed to the president, to the then president, to consider. Reason why they needed this number of justices at the Supreme Court. Is that argument valid in this case as well?
There is a news item that I found online. Would you permit me to read the headline? And it's a news item dated 8th July 2024. Appointment of more Supreme Court judges will ensure effective justice delivery. Godfrey Adami. I want to believe that the reason there is still valid today. I just want to believe so. But you see, unlike the United States of America, you see, the U.S. Constitution does not say that there's the need for only 9 justices. The U.S. Supreme Court doesn't say that. However, they have evolved a convention that have allowed the process to remain what it is. President Mahama had the benefit of becoming president before. And for the 4 years that he became president, he appointed only 2 Supreme Court judges. Prof. Samuel started the process with the appointment of, I think, Justice Badegbe and Co. I think the process didn't end, and President Mahama came. But in terms of he being president, he appointed only 2. His Lordship Justice Yao Apel, and then my Lord Justice Gabriel Kwaman.
Yes.
These 2. This time round, the president has put out there the nomination of 7, with a view that the workload argument that has been made relative to the Supreme Court judges, the 7 that are coming, and always know that the nomination does not mean automatic, it's automatic, because you need to go for parliamentary approval, blah, blah, blah. But at this point, in the wisdom of the president, these 7 on the court would complement. The argument has been made that our Supreme Court, unlike that of the U.S., has too many jurisdictions. And that compounds the work for the Supreme Court judges.
Yo, it for winning and someone about beto. Yepuno so because so when you subscribe to channel area, Bawumia say over subscribe. Now, while I give video, no give us a thumbs up. Now, fi share my or for froso. Now, when you be here now, who and somewhere koso ewo Ghana me muhadam. Also bit me otchere wadwin afa yen some way now ewo comment box mu. Mobeti me carry in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.